Good evening and good afternoon. Good evening in the Netherlands for Tilburg University team, and good afternoon for the team from McGill University. So today we have a match between two teams in the day 3 match of the group phase in Group G. So the two universities will be debating on a topic they received a week ago. This is the third match, so day 3, and for hosting the match, I give the floor to my colleague, Mr. Banova.
Thank you very much, and good day indeed to the two teams participating in this day 3 match. The topic of this match is whether or not marine governance must integrate cultural heritage protection with biodiversity conservation under international law. As always, we'll find out shortly which team will defend which side during the debate. But first, to the teams for introduction, starting with Tilburg University, Ms. Babic.
Hello, everyone. I'm Dora. I'm in my first year of global law in Tilburg, and good luck, everyone, with the match.
Thank you and welcome, Mr. Haddad of McGill University.
Hello, my name is Joe. I'm a second-year law student at McGill University in Montreal, Canada. Really looking forward to doing this debate. Heard great things about Tilburg University, and looking forward to it.
Thank you and welcome, Mr. Billiter of Tilburg University.
Yes, thank you. Good evening or good afternoon, everyone. I look forward to this debate. I'm Theo. I study global law here at Tilburg University as well.
Welcome of McGill University, Mr. Ribeiro Toy.
Yeah, hi. I'm Samuel. I'm also a law student here at McGill. Very excited to partake in this debate and wishing everyone the best of luck.
Yeah, welcome, Mr. Kutima of Tilburg University.
Hi, I'm Bartosz. I'm also a global law student, and it's an honor to be here. Good luck, everyone.
Like indeed, and of course, big thank you to the 3 judges that will be overseeing this match. And of course, in a short moments, you should be able to see the screen with the wheel for the allocation of positions. There are 4 possibilities, 2 for each team, and activating now.
Yes, you can see.
Yes.
Okay. So as you can see, there are 2 possibilities for each institution, for each team, to be in favor or to be against the motion. The team will be in favor, will be starting the match with the first introduction. So Tilburg University will be against the motion. As a consequence, McGill University will be in favor of the motion, will be starting the first introduction. Now you will have 5 minutes to review your notes, and we'll hear the introduction by McGill University.
Thank you, everyone. The time for final preparation has now passed. As always, you will be getting visual cues in regards to your speaking time remaining, so yellow for 30 seconds and red for your speaking time being up. That said, I won't keep you waiting much longer. For the opening statement, McGill University, you have 4 minutes.
Thank you. Members of the jury, one thing is undisputed. The ocean is not just an ecological space, but also a cultural one. Marine environments contain biodiversity, essential to the health of the planet, but they also contain and hold cultural sites like the Titanic, and traditions that define the identity of people across generations. Now, the issue before this jury is whether marine governance must integrate cultural heritage protection with biodiversity conservation under international law. In other words, can international law afford to treat marine ecosystems and marine cultural heritage as isolated interests? We submit that it cannot. It must integrate both. Let me begin with a few definitions from our interpretation of the doctrine. Marine governance refers to the legal and institutional frameworks through which states and international bodies regulate the use, protection, and management of marine species and resources. Cultural heritage protection refers to the preservation of tangible and intangible human heritage linked to the sea, including traditional maritime practices like fishing and sites of historical significance. Biodiversity conservation refers to the protection, restoration, and sustainable management of marine species, habitats, and ecosystems. Our position is simple. International law must recognize that maritime biodiversity and cultural heritage are interconnected insofar as they must be governed together, not separately. First, I will submit that our position is consistent with what international law is and ought to be. That is holistic, preventative, and attentive to the multiple values of the marine environment. Second, my colleague will submit that such integration leads to better governance outcomes, in fact, in practice, by making marine protection more legitimate, inclusive, and more effective. Each submission will be asserted according to the IRAC method, the issue, rule, application, and conclusion. My first submission is that international law already supports integrating cultural heritage protection with biodiversity conservation in the context of marine governance. In fact, international law adopts a holistic and preventative approach to the oceans. Under the UN Convention on the Law of the Sea, states must protect and preserve the marine environment as a whole. And importantly, the convention does not treat cultural heritage as something separate. In fact, Articles 149 and 303 explicitly require the protection of underwater cultural heritage. And this is reinforced further in the UNESCO Convention on the Protection of Underwater Cultural Heritage, which integrates heritage protection into ocean governance. And case law confirms this preventative logic. In the Corfu ICJ case and the ITLOS jurisprudence, such as the southern bluefin tuna cases, states are required to act with due diligence, precaution, and cooperation so as to prevent harm to the marine environment. By applying these principles, separating biodiversity from cultural heritage would contradict the structure of international law. Marine ecosystems and cultural sites coexist physically, but also legally. Damage to one often affects the other. For example, activities like deep sea mining can simultaneously destroy fragile ecosystems and submerged underwater heritage. So because international law requires preventative action and consideration of cumulative impacts, states cannot adopt a fragmented approach. Instead, they must govern oceans as interconnected systems that include ecological, historical, and human dimensions. Thank you.
Thank you very much. And now for the opening statement in the against position, Tilburg University.
Honorable judges, esteemed proposition. Cultural heritage is by definition local, and biodiversity is contextual. But the motion asks us to govern both through a single international framework and call it integration. However, integration is not possible in this case without oversimplifying the core issues. We oppose the motion on 3 grounds. First is the principle of subsidiarity, second is the risk of diversity flattening, and the third is worsening the weak enforcement of current obligations. Firstly, we would like to point out the principle of state sovereignty, which is the fundamental principle of international law. States cannot be obliged to integrate obligations that are currently separate. With this, firstly, I would like to point out that subsidiarity demands cultural heritage governance remain with states. Cultural heritage is inherently local. No international body can grasp the social, spiritual, historical weight of practices the way affected communities can. The principle of subsidiarity holds that decisions should be made at the lowest effective level. Under the EU's TEU Article 5.3, international intervention is only justified when objectives cannot be sufficiently achieved by member states. This is widely recognized in environmental governance. Problems should be addressed at the lowest appropriate level. For example, Palau declares its entire 600,000 square kilometer exclusive economic zone a shark sanctuary, banning commercial shark fishing, which is aligned with the indigenous practice of bull, leaving ecosystems undisturbed. This was a sovereign decision rooted in cultural values which are local and was not an international mandate. To conclude, when cultural heritage aligns with conservation, the best results come from domestic governance, not top-down international imposition. The second argument claims that forced integration flattens diverse situations into one-size-fits-all frameworks. So, heritage-biodiversity relationships vary enormously. Sometimes they conflict, but sometimes they also align. And a blanket mandate cannot accommodate this intricacy. Under UNCLOS, states retain sovereign rights over exclusive economic areas resources, which is enshrined in Articles 56-62, and the UNESCO Intangible Cultural Heritage Convention from 2003 recognizes heritage safeguarding as primarily a state responsibility. So forced integration risks violating the margin of appreciation doctrine that states deserve discretion in balancing competing rights contextually. As evidence, we can also look back to Palau again, because Palau has achieved near 30% nearshore marine protection by 2020 through its own Protected Areas Network Act involving local communities and assessment. And this would be immensely undermined by rigid international mandates. We can conclude that international mandates will risk replacing effective, context-sensitive domestic solutions with blunt instruments. And lastly, we claim that international enforcement is already too weak, and adding complexity will only worsen the problem. Existing frameworks already struggle with enforcement. Adding an integration mandate across two complex legal domains will compound failures. SITES illustrates the enforcement gap. So pacta sunt servanda, which is enshrined in Article 26 of Vienna Convention on the Law of Treaties, means nothing if states lack capacity or willingness to comply. Despite SITES listings in 2013 requiring trade in listed sharks to be legal, traceable, and sustainable, 73 out of 90 nations have never reported any trade, while DNA analysis shows regulated species remain common in Hong Kong markets. And the problem is, if we can't enforce a straightforward trade regulation on 5 species, how can we be expected to enforce the far more complex task of integrating heritage into biodiversity governance? To conclude, adding another layer of obligation to a failing architecture will simply dilute resources without producing outcomes, and it is far better to strengthen the existing mechanisms than create unenforceable new ones. Thank you.
Thank you very much. This marks the end of the opening statements. We'll now proceed to rebuttals. For the first rebuttal, McGill University, 2 minutes.
Well, it is our second submission that integrating cultural heritage protection with biodiversity conservation leads to better governance outcomes in practice, because it makes protection more legitimate, more inclusive, and ultimately more effective. And when we talk about integration, we do not mean fusion. These can be separate topics but work with one another. And international law recognizes that the environmental governance must be cooperative, participatory, and sensitive to context. As my colleague mentioned, under the UNCLOS Articles 192 and 197, states have the duty to cooperate in protecting and preserving their marine environment. But that convention must be read with another convention, the Convention on Biological Diversity, where in Article 8J, it reinforces the position that it is important to recognize the importance of local communities and traditional knowledge when addressing conservation. In Pope Meals on the River Uruguay, the International Court of Justice emphasized the point again. And they mentioned that consultation, cooperation, and environmental assessments are essential to the application of the environment protection. And applying these principles, we get to three conclusions. And it improves governance in three ways. First, it improves legitimacy. When marine governance reflects not only ecological concerns but also cultural and historical values, it is more likely to be accepted by the people most affected. Second, it improves inclusiveness because cultural heritage frameworks bring into process actors that biodiversity regimes simply cannot or may otherwise overlook. And third, it improves effectiveness because integrated governance reduces fragmentation. Instead of protecting biodiversity in one process and cultural heritage in another, states can adopt one coordinated measure. Coordinated measure. Thank you very much.
Thank you. For the first rebuttal in the against position, Tilburg University.
I will start my speech in 3, 2, 1. So I will start by displaying how our points clash with the points of our opponents. So they first mention that the ocean is a culture space, and we agree with this. But it's very important to differentiate between first those intangible values in cultural heritage and fixed historical artifacts, because we believe that basically the arguments that they're invoking only affect those fixed historical artifacts. Then also they invoke that this protection the integration would give more legitimacy. But if we look at the United Nations Convention of the Law of the Sea, Article 136, it only applies to deep seabed and not to intangible resources. We used the example of the Palau shark conservation project, which was successful precisely because of the local nature of the undertaking. So if we look how this clashes with directly with the points involved by our opponents, it's not fragmentation when locality wins. It's not fragmentation when the principle of subsidiarity works. The conservation worked precisely because local people understood how their own culture functions, how their own culture is to be preserved. This cannot be done at the international level. And also, our opponents invoked the 2001 UNESCO Convention, but it's important to remember that most of the leading marine powers rejected this convention. So I would argue that there's no much legitimacy here without major powers participating. Yes, and this is also what my teammate will say in her next speech. Thank you.
Thank you. For the second rebuttal in favor, McGill University.
Thank you. Members of the jury, the opposition's strongest argument rests in the idea that there is a conflict between cultural heritage, which is local, and biodiversity, which is international. But these two things are not mutually exclusive. In fact, their argument supposes as a premise that integration means merging both terms, means fusion, as my colleague rightfully noted, in which case they would be mutually exclusive. But we are not saying that these two terms are substitute for one another. That would indeed be an intellectual shortcut. What we are saying is narrower and more principled. These two frameworks should be considered together because of their commonalities and their overlap in practice. Both aim at preservation. Both are concerned with long-term stewardship. Both protect resources that are fragile, often irreversible once destroyed, and valuable not only to present populations, but to future generations as well. And both are threatened by the same marine activities, including deep sea exploitation, pollution, and destructive extraction. So integration here does not mean erasing legal distinctions. It means coordination. It means recognizing that the marine environment as a whole is not neatly divided between the ecological and the cultural. In reality, these values coexist in the same spaces, they face the same risks, and they often require the same preventative tools. And that is entirely consistent with international law. The spirit of international marine law is not narrow, or it is holistic in structure, and it encourages due diligence, it encourages prevention, and it encourages cooperation across overlapping interests. Thank you.
Thank you. For the second rebuttal in the against position, Tilburg University.
Thank you. Honorable judges and esteemed opposition. The opposition has submitted the following two arguments: that integration is already consistent with international law, and that such integration leads to better governance outcomes. However, we submit that the proposition has presented a very ambitious vision, but ambition is not the same as legal workability. First, on the nature of integration. The proposition has argued that cultural heritage and biodiversity must be governed together under international law, but they have not answered the most fundamental legal question: by whom, through what mechanism, and with what enforcement? Obligations under international law must be sufficiently clear to be binding. That is the very essence of pacta sunt servanda under Article 26 of the Vienna Convention on the Law of Treaties. An integration mandate without an institutional framework, without a dispute resolution body, and without clear priority rules is not law. It is a declaration of intent, and what we are trying to achieve are workable solutions, not mere empty declarations, as is already present in international law. Second, on the enforcement problem. The proposition argues that because current frameworks fail, we need integration, but this is inherently flawed. The failure of CITES and CBD is not a structural failure. It is a failure of political will. Adding a new integrated layer does not create political will. It creates new jurisdictional conflicts, multiplies compliance burdens on developing states, and produces more gaps alongside the existing ones. The answer to weak enforcement is targeted reform, clearer reporting obligations, stronger dispute resolution, genuine capacity building, not systematic remodeling. The proposition asks you to trust a framework that does not yet exist over mechanisms that, however imperfectly, already function. Thank you.
Thank you. This marks the end of rebuttals. For the concluding statements in the in favor position, McGill University, 2 minutes.
Members of the jury, the opposition wants you to believe that because biodiversity and cultural heritage are distinct, they must also be governed apart. They want you to believe that specialization means separation, that cooperation stops at integration, and that the safest legal path to keep a regime is to have two different compartments. They further suggest that under a principle of subsidiarity, that states cannot be expected to take into account obligation that arise from adjacent but formally separate regimes, and that cultural heritage therefore remains legally irrelevant to biodiversity governance. But that argument fails for three reasons. First, distinct does not mean isolated. International law often contains separate obligations that still have to be implemented in a coherent space. The fact that biodiversity law and cultural heritage law have different legal bases does not mean that states must govern the same marine space as though the interests are not intertwined. Second, integration is not fusion. We are not arguing that one system of protection observes the other or that states suddenly acquire new obligations. We are arguing that for coordinated implementation where biodiversity and cultural heritage arise in the same marine space, they should be governed together. The other party mentions pax sunt servanda, and our position aligns with that. States can discharge their existing obligations in a way that takes both into account the realities of the sea and of the cultural heritage. Thirdly, even if different institutions have specialized mandates, that does not mean that every decision maker may ignore a broader factual and social context. We, however, submitted two submissions that align with the principles of international law. First, that aligning both regimes would be more better to implement, but also lead to better outcomes. And we therefore urge you to find this motion in favor of our position. Thank you very much.
Thank you. Tilburg University for your concluding statements in the against position.
Okay, I'll begin my speech. 3, 2, 1. Honorable judges, throughout this debate, we have demonstrated that marine governance must not integrate cultural heritage protection with biodiversity conservation. Well, this is about preserving the local nature of cultural heritage when great powers often disregard the historical weight. Now, my teammates have demonstrated that, first, the principle of subsidiarity demands that cultural heritage governance remains within states, not international bodies, and second, that forced integration risks more harm than good because it flattens those diverse situations into the sort of one-size-fits-all framework. Now, our dear opponents argued that integration already exists in international law. Well, we disputed that by saying that first, we believe that their framework is way too ambitious, but practically impossible, which we have proven with the UNESCO Convention being quite controversial with powerful states. And additionally, our opponents argued that, and I quote, integration is not fusion. While we may agree with this, this statement alone does not constitute a functional legal model or a functional legal framework. So we believe there's no much substance here that actually proves this point, other than just saying it would be nice if everything was good. But well, that's reality. Also, we argued that it's not a failure of locality and the failure of local action, but more of a failure of political will at the highest level. So as we have highlighted, adding yet another level of international obligations to an already failing enforcement architecture will dilute those limited resources and attention without producing meaningful outcomes that can be achieved on a local level more effectively. So for these reasons, we ask you to reject the motion. Thank you.
Thank you to both teams. You can all now relax. You're no longer graded after this part. Of course, the judges do have the time to review your match, submit the scoring cards, but already now, as is our tradition, I would really like to encourage you to share your experience and your view both on the topic, the research, perhaps if you're familiar with it, as well as today's exchange, maybe a familiar arguments from your own research were present in the opponent's arguments. And so passing first to Ms. Babic of Tilburg University.
Well, sorry about that. To be honest, this was my favorite motion of the entire debate. It was interesting. It was very specific, but still allowed a lot of flexibility. And we did debate more economic motions earlier, and I enjoyed this type of topics more. So I enjoyed that. Yeah, and the research was therefore also more fun for me personally, at least.
Thank you. Same question to Mr. Haddad of McGill University.
Yeah, I share the same opinion. I think it was very interesting to delve more into that world and see how things are, how things should be. But yeah, it was definitely an interesting motion. The only thing I really I found really interesting was at the last rebuttal of Tilburg. They mentioned that there was not a full system, that we didn't suggest a full system with a dispute resolution mechanism and all that sort of stuff. And I mean, I feel like had we had more time, that would have been interesting to kind of explore alternative I guess mechanisms to ensure that what we're suggesting is implemented in I guess in an efficient fashion. But yeah, no, it was a really nice debate, and I really enjoyed the research and the debating.
Thank you. Mr. Kutima of Tilburg University.
This was certainly the most challenging for me personally. I quite enjoyed those economic motion before, so yeah, certainly a new challenge here, but I felt a little bit shaky. Yeah.
Yeah, well done to the teams for so far, really. Mr. Ribeiro Toy.
Yeah, definitely a quite an interesting topic, very niche. I am of the opinion that I like more economic debates, so we're kind of split in our team as well. But yeah, but it was very, very fun. I think there's a lot of space to invent, and no, we could get to the same conclusion by taking different means. So it's pretty interesting to see the topic on debate.
And Mr. Bilater.
Yeah, I mean, I agree with that this was probably my favorite prompt out of the two that I debated. I also want to firstly also congratulate the other team, because you guys had very strong arguments. but yeah, it was very enjoyable also, and I also second the idea that if we had more time to kind of develop the arguments, that would have also been great, because then we could have gone more into the depths of this. And I think that goes for all of the prompts. Obviously, there's so much depth to it, that yeah, if we had some more time, it would be fun to explore the specificalities of them all. But yeah, of course, that's not always possible.
Thank you, everyone. Really, from the behalf of the organization, we hope that the topics have been, I would say, both academically stimulating, but also perhaps a professional interest might have stirred as you were doing the research. And there have been quite a few over the days for the debate so far. Is there anyone you would like to give a shout out to for the encouragement, motivation, or other support during the debate so far? And first, passing this question to McGill team.
I don't know if Sam agrees, but I would shout out my good friend Amir Sayafi, who's who was really interested, very intellectually stimulated by international law and by the law in general. And we kind of got to run our arguments through him and what he thought of them, and he kind of helped us tailor everything together. So shout out to Amir, who really helped. I don't know if Sam agrees. Do you agree?
Oh yeah, Amir was quintessential to our help. He kind of served as a judge as we went through the argument. He kind of served as a judge just to make sure that we're speaking clearly, that everything's working well. So I just want to thank him for all the time he spent.
And now to Tilburg University team.
Yeah, I think for us, we also have like our two coaches, Denitsa and Dejan, who both participated last year. Of course, also shout out to them. Also for Elsa Tilburg for also helping us make this possible for the internal round as well. It was yeah, great to also have that be possible. I don't know if my teammates have anyone else to add.
No, I completely agree. Yeah, to our coaches and of course to Elsa. Yeah.
Yes, I think the same.
All right. And honestly, it's been a pleasure to see all the teams, yours included, progress from your very first debate. We do have Mr. Haddad. We were able to see him also in concours in the last year's edition, so that's extra new step. So if you do want to explore the French side of debating next year, that's a possibility for the other teams. But over the course of your studies through your curriculums, but also in the debates so far, you have encountered several different areas of law, legal systems. Is there any particular one that stayed with you, or perhaps one that you haven't had yet a chance to explore, that you would like to either learn more about or engage with as a practitioner in your career? And this time first to Tilburg.
Well, I am very interested. I mean, what I would like to pursue later is an intersection of law and technology. I think that would have been very interesting to see also as a topic debated here, but also it's such an overdone topic sometimes. So if it's not addressed properly, it can also be super boring and feel quite stale. But yeah, definitely in the future, I would like to go in the direction of intersection of maybe AI and IP law or AI and cybersecurity. That's very, very interesting to me.
Yeah, I think. Sorry. Yeah, from my side, I really enjoy. I mean, it's strange because I enjoy very public fields, but also very private fields. So I really enjoy competition law, for example. It's quite fun. But also public international law, like something along the lines of international environmental law and just generally in front of the ICJ. It's also great and very interesting. So yeah.
Yeah, I was a business student, so I'm more of a finance person at heart. So I would say some maybe like antitrust law or tax law in the future. So more of a tangible examples.
Yep. And the team in Montreal?
I'm more interested in mergers and acquisitions, because and especially in Canada, there's kind of this cross-border ability like or practice that I could have. So combining business and I guess the cross-border element to it, which I feel very appealing, which I think is very appealing.
Yeah, and I'm completely the opposite. I am interested in litigation and litigation only, primarily commercial securities and white collar investigations. I think. I mean, you asked a question about legal traditions, and nobody really addressed what's their favorite legal tradition. So I'll say something here. I do think that civil law is a better system, although we are in Canada, we're primarily a common law. No, we're primarily common law jurisdiction except for Quebec. And yeah, I think common law makes it more exciting than civil law sometimes, because civil law, it's you have to really stick to your code or you stick to the statute. In common law, you can sometimes throw something random at the judge, and he'll find a way to invent something. So I do think that for a litigator, common law tends to be a little bit more exciting. So yeah.
Right. Well, exciting times ahead, I believe, both for your studies and your careers. Just for the fact that you are in the competition so far proves that you are going the extra mile, both for yourselves and also representing your teams. We would really encourage you to keep in contact, both within your groups, but also the next moment we see each other is in the mid-edition break networking event. So you'll see everyone in your group, but also from the other groups. And there are quite a few fellow students across different jurisdictions that share your various interests in legal areas. So that is a good way to also explore the network that you have through the competition. And just for the technology part, there is an upcoming round with this as a focus for the debate statement. So keep an eye out for that. But yeah, passing to Professor Lavange to wrap us off. Well done, everyone.
Yes, it was a very, very good match, and I see that indeed you invested a lot of time and effort for the research, for brainstorming as well, with a coach, with as well fellows, and on those topics. So congratulations, because that is a culmination of all your efforts after these 4-5 weeks. And another element, obviously, is the networking part. So Tilburg team comes sometimes at the networking event, at the very end, at the reception in June. So we already had the pleasure to have some members from Tilburg coming to The Hague in June. So yeah, if you want to come, you're welcome. And of course, Mr. Haddad, knows as well the reception of last year. So when he came with his colleague, so yeah, you can meet in person actually in real in June if you want in The Hague. So this is what I wanted to tell and encourage. So congratulations again. In a few days, of course, you will receive the results from this match before we'll publish it. And yes, so it was a pleasure to have your free match, and of course we're looking forward for the next step, and of course the networking event in April. Voila, so thank you again, and congratulations, and we keep in touch, and as well thanks to the students who help you as well around, and the Student Association. So thank you, bye-bye.
Thank you.
Thank
Have a
you.
nice day.
Bye.
Thanks so much.
Bye.
Bye, going everyone.